Commissioner, when does your term of office expire?
My term expires, I think it's November either 9th or 12th next year.
Of 2017?
Yes, I've made it clear. I serve at the even with a fixed term, I serve at the pleasure of the president. So whoever the new president is can decide to make a change if they'd like.
So you will offer a resignation, whoever comes in, and you'll offer to step aside?
I know I have a fixed term, so unless I actually don't want to fill out my term, I serve at the pleasure.
I understand that, but when you say you serve at the pleasure, meaning that if the president came to you and asked you to step aside, you would.
I would.
If you got fired, but you're not going to offer to step aside unilaterally, correct?
That's correct.
Okay. Now, there's been talk about due process, but I just want to, for the record, we did have a hearing in this committee, I think it was in July, and you were invited to come to that first hearing, correct? And you chose not to?
Sure. No, as I explained to the chairman, I had just come back from abroad, and I had a hearing the next day. I explained to the chairman I would be delighted to come anytime, and I've been delighted on relatively short notice to be here today.
Okay. Now, I want to look at your testimony today because there's been a lot of talk, I think justifiable, about some of the things you've said over the course of the investigation that later turned out to be false. Now, today you testified that the IRS ended the use of BOLO lists more than 3 years ago. And that's your testimony, correct?
That's my testimony.
Well, how does that square with the D.C. Circuit opinion where the IRS made that exact same argument and the court rejected that? They said, no, you have not ceased the conduct. You have chosen to suspend the use of BOLO lists, which means that you're free to attend, you're free to return to the offending conduct. And that's what the court found. So for you to say you ended the lists when in fact you suspended them, that's not just me being nitpicky. That is a distinction that the court seized upon and justified in its ruling against the IRS. Shouldn't you have said that you suspended the use of BOLO lists?
No, that's Justice Department has the litigation, and that was what they provided. The IG reviewed this matter over a year and a half ago and agreed that we had terminated. I wrote a letter to all the oversight committees saying it's been clear, however you call it, terminated, suspended, ever.
Well, it matters legally because if you're suspending it to try to get through a case and then you could return to it, the court thought that that was important.
Yes.
So there's no document, though, that says you've ended, or does it say you suspended it?
It ends, and I will be happy to share with the committee the instructions given to all people in the exempt organization decision with regard to this matter, and those instructions went out 3 years ago, and we'll share that with you. The other point...
The court rejected that. I mean, you agree with that. The court rejected that.
The
court found that the IRS has simply suspended the use of BOLO lists, but that you guys have not proven to the court, which that would have been the time to do it, that you will not return to the offending ways subsequent to the litigation.
Well, I can't speak for the Justice Department would handle the litigation. All I can tell you is we have provided all of the oversight committees with the note that we have committed and have terminated the use of BOLO lists. The question about the 3 that were pending, for 50 years, if you are involved with us and then you suddenly go to court, we don't continue to process the audit or the return.
But the court rejected that argument, as Mr. Jordan said. To be fair, the court said that puts people in a catch-22 because you tell them you're going to violate their rights, and then if they seek litigation to get their rights, then you say, well, we're going to continue to violate your rights until the case is over. And the court thought that that was unacceptable, and I do too. But let me move on. You have admitted that the subpoenas that were issued for learners' emails, that the IRS did not comply because there were tapes that were destroyed, correct?
That's correct. I mean, if we did not, we're supposed to produce evidence, we could only produce the evidence we have.
And I think that you've acknowledged that your June 20th, 2014 testimony, you did testify falsely because you said, quote, everything has been preserved, nothing has been destroyed. And of course, as we've established in March, just a few months before that, there were tapes that were destroyed containing pertinent emails. You also testified that day that you, quote, that the IRS confirmed that backup tapes no longer existed. I remember that exchange because I was sitting there. They drilled down to you. What does it mean by confirmed? And you said it meant somebody went and checked. And of course, that wasn't true because although the IRS had destroyed 422 backup tapes, the IG did find backup tapes that were still in existence at the time you made the statement. You also testified at your confirmation hearings that you believed in transparency and report problems as soon as you knew about them regarding the learner production, but you've acknowledged today that you waited 2 months and that that was a mistake. One of the other things you said was that the IRS went to, quote, great lengths in order to provide Congress with the material that it requested. You remember making that statement?
I do.
Is that false? Did you go to great lengths to provide it? And here's why I ask that. Nobody in your organization ever went to the Martinsburg, West Virginia warehouse where they had the backup tapes. I put it on Google Maps today. It's about 76 miles from the District of Columbia. You've complained about how costly it's been to provide information to Congress in the past, but in fact, that would have taken probably a tank of gas to get there and back. And yet the Inspector General, when they went there, even though you said you went to great lengths, nobody from your organization had ever gone to retrieve any backup tapes. Isn't that true?
We went to great lengths to respond to the congressional request.
But those
We
great
provided-
lengths did not involve getting in a car, driving 76 miles, asking for the backup tapes, and then bringing them to Congress. That was a bridge too far for you. So I'm almost out of time. Let me just end with this.
Okay.
There's been disputes about, did he order the tapes destroyed or whatever? I don't think that that's even the standard. Obviously, if you did that, that's a no-brainer. But I believe Justice Story was right when he talked about impeachable offenses being political offenses that grow out of personal misconduct or gross neglect. And he said they must be examined upon very broad and comprehensive principles of public policy and duty. I think that the IRS had a duty to provide Congress the information. The IRS breached the duty. I think you had a duty to display candor in front of Congress. I think your false statements, although you can say you didn't intend them, I think had you investigated more, you would have known. So I think it's really about breach of duty and about the gross negligence that's at issue here. I'm out of time and I yield back.